all state organs, and therefore, quote, any law, including customary law, that is inconsistent with this Constitution is void to the extent of the inconsistency, and any act or omission in contravention of this Constitution is invalid, end quote. The power of the court to review acts of the legislative and executive arms of government which can be demonstrated as affecting constitutional rights and fundamental freedoms of the citizen is, from this authoritative provision, axiomatic. Yet the exercise of this power by the courts, though constitutionally sanctioned, has been a source of endless misunderstanding and friction. Whenever it is exercised, the executive and the legislative arms of government have many a time accused the judicial arm of overreaching itself. This notwithstanding, the judiciary must always be true to the Constitution, whose edicts it must declare without fear or favor, and accept that it may not always receive accolades for doing so. Generally speaking, the legislation is presumed to be constitutional because it is assumed that in enacting the law, the legislature does so on behalf of the populace with a view to addressing their needs and problems. The people's representatives are expected to enact only laws that they consider to be reasonable for the purpose for which they are enacted. But this is a rebuttable presumption. As such, the power to question the constitutionality of a statute is circumscribed by many conditions. For example, it was stated in the Canadian case of Queen versus Big M Drug Mart, which has been applied in many decisions in this country, that, and we quote, both purpose and effect are relevant in determining constitutionality. Either an constitutional purpose or an unconstitutional effect can invalidate legislation. All legislation is animated by an object the legislature intends to achieve. The object is realized through impact produced by the operation and application of the legislation. Purpose and effect, respectively, in the sense of the legislation's object and its ultimate impact, are clearly linked, if not indivisible. Intended and achieved effects have been looked to for guidance in ascertaining the legislation's object and thus validity, end quotes. Similarly, in the often cited judgment of the Constitutional Court of Uganda, which we referred to earlier, Olum and another, the court restated those principles thus: to determine the constitutionality of a section of a statute or act of parliament, the court has to consider the purpose and effect of the impugned statute or section thereof. If its purpose does not infringe a right guaranteed by the Constitution, the court has to go further and examine the effect of the implementation. If either its purpose or the effect of its implementation infringes a right guaranteed by the Constitution, the impugned statute or section thereof shall be declared unconstitutional, end quotes. The question before the High Court, and indeed in this appeal, is whether the purpose for which Section 39(2) and 3 of the Act and Regulations 83(2) and 87(2)(c) were promulgated, or the effect of their implementation infringes any provision of the Constitution. The burden was on the first, second, and third respondents to demonstrate that the impugned provisions were enacted or made for an unconstitutional purpose, or that in their operation and application they have an unconstitutional effect. We start by testing those provisions against Articles 86C and 138(3)(c), the general constitutional principles and the general principles of the electoral system in Article 81. On the general principle of the electoral system, Article 81 provides, and we quote, "The electoral system shall comply with the following principles. A, freedom of citizens to exercise their political rights under Article 38. E, free and fair elections which are 2, free from violence, intimidation, improper influence, or corruption. 3, conducted by an independent body. 4, transparent. And 5, administered in an impartial, neutral, efficient, accurate, and accountable manner," end quotes. Article 82 enjoins Parliament to enact legislation on election that will ensure that, quote, "voting at every election is A, simple, and B, transparent," end quotes. Regarding voting method, Article 86 commands that, we quote, at every election, the Independent Electoral and Boundaries Commission shall ensure, A, whatever voting method is used, the system is simple, accurate, verifiable, secure, accountable, and transparent. B, the votes cast are counted, tabulated, and the results announced promptly by the presiding officer at each polling station. C, the results from the polling station are openly and accurately collated and promptly announced by the returning officer. And D, appropriate structures and mechanisms to eliminate electoral malpractice are put in place, including the safekeeping of election materials, end quotes. Article 138(3)(c), on the other hand, stipulates, we quote again, "In a presidential election, C, after counting the votes in the polling station, the Independent Electoral and Boundaries Commission shall tally and verify the count and declare the result," end quotes. How are Section 39(2) of the Act and Regulations 83(2) and 87(2)(c) said to be inconsistent with the foregoing provisions and principles? Section 39(2) and 3 states as follows, we quote, "The Commission shall determine, declare, and publish the results of an election immediately after close of polling. Before determining and declaring the final result of an election under subsection 1, the Commission may announce the provisional results of an election. We have emphasized the Commission may announce the provisional results of an election. 3, the Commission shall announce the provisional, again emphasize the provisional and final results in the order in which the tallying of the result is completed, end quotes. We also reproduce here below Regulation 83.2 and 87.2c. 83.2 says, the results of the presidential election in a constituency shown in Form 34 shall be, and we again emphasize, shall be subject to confirmation by the Commission after a tally of all the votes cast in the election. 87.2, the returning officer shall, after tallying of votes at the constituency level, A, announce the result cast for all candidates, B, issue certificates to persons elected in the National Assembly and County Assembly elections in Form 38 set out in the schedule, and C, electronically transmit, again emphasis, electronically transmit the provisional result to the Commission, end quotes. The first, second, and third respondents are concerned that whereas Article 86 and Article 138 make no reference or mention of the results from the constituency being provisional or subject to any confirmation, the terms of the impugned provisions suggest that those results can be interfered with at the National Tallying Center by the chairperson of the appellant, who it designates the returning officer for the presidential election, yet the results announced at the constituency tallying center are final. Giving his views before the Kiraitu Orengo Committee, the then chairperson of the appellant, Ahmed Isaac Hassan, explained the mischief and reason why those results were considered provisional and subject to confirmation. He is recorded in the report as having said the following, quote, the chairperson further submitted that the results received under the system were provisional results under the Elections Act and the Elections General Regulations because every returning officer had to bring the physical form to the county returning officer. Now they quote the chairperson himself. This is what he said. So they do not replace the official legal announcement of the results by the returning officer and the paperwork on the forms 36, 37, and 38. These forms in the Elections Act are prescribed forms and they form part of the law, end quotes. We are still quoting the Kiraitu Orengo report. They say at paragraph 486, with regard to the current transmission and declaration of results, the chairperson of the Independent Electoral and Boundaries Commission stated that, this again quoting the former chairman, a presiding officer is the first point of call for results. He opens the ballot box, counts the ballot papers first for president, and declares the results there. End of quotes. The then chairperson further gave a roadmap of how the results of the 2013 elections were transmitted from the constituency to the county tallying center, to the constituency and the county tallying centers, and finally to the national tallying center. That at the constituency tallying center, the final results of Member of Parliament for the constituency and also Member of County Assembly were declared, in quotes, were declared. However, the results of each presidential, gubernatorial, senatorial, and woman representative candidates in that constituency were only announced for the reason that they were provisional and subject to confirmation. Thereafter, the results for the governor, senator, woman representative, and president were taken to the constituency returning officer, to the county returning officer, who declared the winner for the seat of governor, senator, and woman representative, but only announced the presidential result as received in the county before being brought to Nairobi. He concluded his presentation saying as follows: ultimately, all the 290 returning officers from each constituency came to Nairobi with the presidential results which they had announced at their constituency. The 47 county returning officers also brought their results from each county. These results were published online on the Commission's website. Even as the commissioners were reading the results as given to them by the officers were seated in the auditorium, end quotes. Being of the view that the procedure enumerated above was not only cumbersome, but also susceptible to serious risks of manipulation, the committee made this recommendation at paragraph 489 of the report. Quote, that the Elections Act be amended to provide for the electronic transmission of the tabulated results of an election for the president from a polling station to the constituency tallying center and to the national tallying center, end quotes. Following that and other recommendations, the Act was extensively amended by the Election Laws Amendment Act number 36 of 13th September 2016. For our purposes, to Section 39 was introduced subsection 1C, which specifically provides for the transmission of presidential results. It reads, and I quote, for purposes of a presidential election, the Commission shall A, electronically transmit in the prescribed form the tabulated results of an election for the president from a polling station to the constituency tallying center and to the national tallying center. B, tally and verify the results received at the national tallying center. And C, publish the polling result forms on an online public portal maintained by the Commission, end quotes. Pursuant to the constitutional principles of transparency, impartiality, neutrality, efficiency, accuracy, and accountability under the present legal regime, in a presidential election, the votes cast at each polling station shall be counted, tabulated, and the outcome of that tabulation announced without undue delay by the presiding officer. The results announced at each polling station shall be transmitted to the constituency returning officer, who in turn will openly and accurately collate the results from the various polling stations in that constituency and then promptly announce the outcome of the collation. From the constituency tallying center, the returning officer will electronically transmit the results directly to the National Tallying Center. The dispute is on what should happen at the National Tallying Center, while the appellant and the fourth respondent insist that by the provisions of the Constitution, the Act, and the regulations, the appellant is authorized to verify the results and to confirm them. The first, second, and third respondents, as well as the fifth and sixth respondents, for their part, have maintained that the results declared or announced at the polling stations are final and no person, entity, or entity can purport to have power to verify or confirm or vary them. From our own reading of all the provisions under review, the authorities relied on in this appeal, and bearing in mind the history that we have set out in detail in this judgment, we are convinced that the amendments to the Act were intended to cure the mischief identified by the then chairperson of the appellant and other stakeholders. That mischief was the spectacle of all the 290 returning officers from each constituency and 47 county returning officers trooping to Nairobi by whatever means of transport, carrying in hard copy the presidential results which they had announced at their respective constituency tallying centers. The other fear was that some returning officers would, in the process, tamper with the announced results. One of the factors in the electoral system reform that was underscored in 2016 and 2017 amendments to the Elections Act was the use of information technology to guarantee the accuracy and integrity of the results of elections. Section 44 was introduced in the 2016 amendment to provide inter alia that the appellant shall, and we quote, establish an integrated electronic electoral system that enables biometric voter registration, electronic voter identification, and electronic transmission of results. 3, ensure that technology in use under subsection 1 is simple, accurate, verifiable, secure, accountable, and transparent. 5, in consultation with relevant agencies, institutions, and stakeholders, including political parties, make regulations for the implementation of this section, and in particular, regulations. In 2017, end quotes, in 2017, Section 44A was inserted after Section 44 to provide that, and we quote, notwithstanding the provisions of Section 39 and Section 44, the Commission shall put in place a complementary mechanism for identification of voters and transmission of election results that is simple, accurate, verifiable, secure, accountable, and transparent to ensure that the Commission complies with the provisions of Article 38